So in this session, we have Dean Kaplan, who's a former diplomat and part of Visa 101, and Duden, who's also part of Visa 101 and founder of Letelier Consulting. And they'll be taking us through the preparation strategies required for navigating the USCIS petition and other visa types compared to the consular process. So over to you guys.
Fantastic. Hi, everybody. It's very nice to be here. Thank you to Unshackled for organizing this and for inviting us to speak. I am here with Dean, and we're very excited to be giving you this presentation tonight, and we look forward to your questions at the end. I hope you can see the slides, correct?
Mm-hmm.
Okay, fantastic. So as was mentioned by Priya, Dean and I are both with Visas 101. We are both former visa officers and consular managers, and we've served around the globe in different countries, and we have seen way too many unnecessary denials at the window. That is really truly the primary reason why we have come together and we have established Visas 101. And the reason behind it is we saw so many applicants at the visa window who simply were just not as well prepared as they should have been. And their visas ended up getting denied or delayed. And that is what we want to try to help you avoid with this session and with the services that we offer. We're proud to say that Visas 101 is the first educational platform for visa applicants. And I'm going to send it over to Dean to talk a little bit about his background, and then I'll share a little bit about mine. Dean?
Thank you. Yeah. Hello, everybody. Very nice to be with you, and I'm glad you're here tonight. Yeah. So I am a former Foreign Service officer, U.S. diplomat. I was with the State Department for 20 plus years. Most of my assignments were consular related, and I served in Nigeria and Nepal, in Israel and in Spain, and then in a number of positions back in Washington, including some fairly senior positions in the visa office, dealing with various topics related to visas and some topics related to American citizens. So lots of consular experience. I've been both a consular officer working on the line and a consular manager at embassies overseas. And in fact, as a consular manager, I also worked on the line with my officers to make sure I knew what was going on with the applicants. So back over to you, Duden.
Yeah, thank you, Dean. And in fact, Dean is a rather humble person, but in my opinion, he's absolutely one of the most experienced consular managers who have since left the department. So we're very lucky and privileged to have him join us tonight to give us his perspective and share with us his wisdom. But I had the privilege of working for Dean in Madrid. He was my visa chief. And that is when I interviewed more than 17,000 visa applicants, both non-immigrant and immigrant, petition-based and non-petition-based. But one thing that I think separates me from a whole bunch of other former visa officers is the fact that I've been on the other side of the window too. So I am an immigrant myself, and I applied for several visas in my lifetime. And I've even been a petitioner on the other side, applying for family members to come join me in the US. So happy to be here and happy to be doing this with Dean. Please do follow us on social media. We are on various platforms. We do share some tips along the way. So these are some of our handles on social media. And over to you, Dean.
So we're going to talk a little bit today in particular about petition-based employment visas, both the non-immigrant types, the H's, the L's, the O's, the P's, the Q's, the R's, as well as the employment-based immigrant visas, the E's, EB1 through 5. I'm sure you all know, but, petition-based visas have a two-part process. The first part is the petition that is submitted to USCIS, and the second part is the visa interview. In the first part, tends to be very document heavy. It tends to be very, often lawyers are involved, putting together a lot of, laying out legal cases, why the petitioner is an appropriate petitioner, why the applicant meets the qualification, maybe there's a labor certification. And that petition approval is required for the visa interview. If it's a non-immigrant visa case, it goes through the Kentucky Consular Center from USCIS to the post overseas. And if it's an immigrant visa, then it would go from USCIS to the National Visa Center to the post overseas. The consular piece of this is really interview focused, right? That's the center of it. It's not so much about a lot of documents, although sometimes documents are important. But what's really important is that in-person interview with the consular officer at the embassy. And that visa is required, even though the petition might be approved, you can't travel without that visa issued by that consular officer. Over to you, Duden.
So I'd like to kind of separate the two processes a little deeper, because I know many of you, if you're starting the petition process, you know what you're doing. It's with USCIS over at the Department of Homeland Security. So it's a completely different department altogether. With your visa interview, it is handled entirely by the Department of State. So these are two separate departments under the US, federal system. And with USCIS, the officer that is reviewing your file is in the US. They're looking at it from, as Dean said, a paper-based application. When you apply for a visa, the officer you're going to be interviewing with is going to be overseas. And it's going to be a State Department official who is serving overseas as a US diplomat. So a little bit of a different situation, different offices, different personnel that are handling your case at the different stages of the process. Now, what is not a visa interview is it is not a rubber stamping of your USCIS approved petition. So oftentimes I hear applicants say things like, oh, I'm just going to do the, just the necessary visa interview, and they expect everything to just go super well and they get approved a visa because, hey, they have an approved petition. So this is not a rubber stamping of your USCIS approved petition, number one. Number two, it is not a visa stamping. Now, this is one of Dean's pet peeves. I remember when I worked with him in Madrid, and people would say, oh, I'm just here to get my visa stamped. You're not here just to get your visa stamp. We are not visa stampers in a passport. Literally, this is an interview to confirm everything you have put in your visa, in your USCIS petition. Remember, this is the first time that you're actually face-to-face with a US government official. Until your visa interview, everything is based on paper. There is no one-on-one interaction between you and a US government official. This is the first time it actually happens, is at the visa interview at a US embassy or consulate overseas. So the officer in this interview is confirming that everything that has been put on paper is indeed correct. So please do keep that in mind and remember what a visa interview is and is not. So I'm going to send this over to Dean now.
So, yeah, thank you, Duden. So can an officer deny a visa that's based on an approved petition? I mean, it absolutely happens. They can be denied under 221G. That often is if there needs to be administrative processing on the case, or if there's some documentation that's required that's missing. The easiest example is a non-immigrant, non-petition case, but if a student applied for a student visa and they only had a photocopy, not the original I-20, the case, and they were otherwise qualified for the visa, the officer would have to refuse it until the original I-20 was provided. So that's an example of 221G for missing documents. It's rare, but some petition-based cases can be denied under 214B. O1s, for example, the applicant does not have to have a residence abroad that they don't intend to abandon, but you do have to overcome the presumption of immigrant intent. Normally, that's sort of baked in, but depending on a person's history, that could be an issue that comes up. And then, of course, they're also subject to denial under other grounds of the INA. So if somebody 20 years ago was arrested for I don't know, robbery, and they have a crime involving conviction for a crime involving moral turpitude, then they might be otherwise qualified for that petition-based non-immigrant visa or that petition-based immigrant visa, but they would need a waiver of that ineligibility. And for non-immigrant visas, that's decided by CBP. The consular officer submits that on the applicant's behalf. For immigrant visas, the applicant submits it directly themselves to USCIS.
Great. Thank you, Dean.
So as you're thinking about this, some things to think about, some red flags to watch for, things that are going to draw the attention of the officer, previous visa denials. If somebody has been refused a B1, B2 multiple times and then is suddenly applying for an O1, that may raise some additional questions. Doesn't mean they can't be answered and resolved, but it may raise some additional questions. So one would want to be prepared for that going into the interview. Frequent encounters at secondary inspection, the consular officers, if those were significant, we'll see that and may have some questions about that. If during the USCIS petitioner process, there were a number of RFEs, requests for evidence, that were ultimately resolved, but if those raise some questions that might draw the consular officer's attention, you would want to be prepared to be able to talk about that. And then any of the other sort of legal issues like the other bases for ineligibilities that I had mentioned. Over to you, Duden.
So some top tips for your visa interview. Number one is, of course, please be honest. I know this goes without saying, but some things may come up that make you uncomfortable during a visa interview. Please answer the questions as truthfully as you can. That is really going to be your best bet at a visa interview, because you don't want to give a misrepresentation of a material fact. If you do, that may make you ineligible for a visa. And one thing I will mention, because I know a lot of you are looking at petition-based visas, you have to know your petition in and out. I know maybe an attorney prepared it for you or helped prepare it for you, and it's a big file, about this big, so many papers. Know your petition inside and out. Know the awards you got, the publications that you've been featured in. What are the things, if you're applying for an O1 or an EB1, what are the things that make you extraordinary according to the petition that you've submitted? Know all of the details of the petition so you're not scrambling through paper. You're able to articulate that verbally during your visa interview. And then last but not least, prepare. I think preparation is really the key to having a successful visa interview. You need to be able to already know in your head the kinds of questions that are going to come up at the visa interview, the kinds of answers you're looking to give to be able to support your case. If there are any issues that potentially raise red flags in your case, know what they are, so you're going to be able to address them very clearly and effectively during the visa interview process. And of course, you don't need to do this alone. I mean, this is why I think Unshackled was formed. It's to be able to provide a really nice community for individuals who are in a similar situation as yourselves, who've maybe been through the ropes before, but we're also here as a source of support for you. You don't need to do this alone, and we're happy to help you get across the finish line. I know it's the Olympic season, so we wanted to kind of draw upon that. Just as you would prepare for the Olympics, you have to see the visa interview process and the whole petition process in a similar fashion. This is the moment of your life that is going to be determining your future. So without a successful visa interview, we don't want your dreams to fall apart. So we are here to support you as best as we can. And one of the things we have done as part of our platform, Visas 101, is launching courses to help visa applicants. And now I'm going to send it over to Dean to talk about our B1 B2 Visa Masterclass, which I know is not probably the visa you're looking for, but how can it still be helpful to you? So over to you, Dean.
Thanks, Duden. Yeah. So yeah, B1, B2 is different than petition based, no doubt. The sort of the basis for approval, some of the facts required are different. And of course, there's no petition of B1, B2. But the course, as you can see, really walks through sort of soup to nuts the full visa process. So talking about the application process, how to complete a DS-160, how to schedule an interview, how to prepare for the interview, how to gather supporting documents, what happens at the interview, what happens afterwards, traveling in the United States, all of those things. And so even though the course is directed, for example, at B1, B2, understanding what the visa interview is, what the consular officer is trying to accomplish during the interview, and how you can best prepare yourself is really universal for any non-immigrant visa. So it would apply, and I do think it would be useful. Another thing to be aware of is that the course comes with some bonus materials, including self-reflection questions. And in fact, the course, people who sign up for the course get access to the course for a year. So even if you were just now sort of in the middle of the petition process and you signed up for the course, you might start it and review it and go through it. And then 6 months from now, the petition's approved, your appointment's scheduled, you can go back and watch module like 6 and 7 and 8, because those are the ones that are most relevant for you at that moment to sort of refresh your memory and get yourself prepared. There's also a monthly Q&A where folks can join and submit questions, and then we go online and talk about those topics that are raised by participants in the course.
Absolutely. And if you need more personalized assistance, we're also here to be able to help you with that. So we do offer 20-minute and 45-minute sessions one-on-one. If you have several questions, for example, about your particular case, maybe a 20-minute session is going to be enough for you to ask those questions and get specific personalized answers based on your profile and application. However, if you'd like to do a mock interview to get an experience and an idea of what that interview process is going to be like, we're happy to review your petition, look at your DS-160, and then conduct a mock or interview or two during a 45-minute session. So that's also something else that we offer, and we highly encourage you to take advantage of it if it is something that you're interested in. Dean?
So there's a couple of different ways to approach this. You know, for some folks, doing the master class is helpful and it's sufficient. For some folks, they don't want the master class, but they do want to do a mock interview or have a consultation because they have some very specific questions. I would propose or suggest that taking the class will sort of distill for someone the things that they really understand and are prepared for, and then the places where they really do have questions. And that is the kind of thing that can make the consultation most effective, right? Because there's not a lot of time spent on other things that might be covered in the class. It's really focused on those things that are specific to the particular applicant. And the way we've set this up is that if somebody takes the class and they want to do a consultation, then they get a discount on the consultation. Because we want to make it's important to us that this is as accessible as possible. That's why the class is relatively inexpensive. It's worth a lot more than we charge for it.
Absolutely. And as we've said, we want to help you get across the finish line. That's why we're happy to do this webinar and answer your questions during the webinar. But we want you to see us as your partner in your journey. So happy to take questions at this time, Priya.
Oh, I'm not seeing any questions or raised hands, but guys, do you guys have questions?
I will say too, we're going to do another one of these sessions next week, specifically on B1, B2s for family members of folks that are on O's and H1Bs and L's who might want to come visit. So we'll be getting into the nitty gritty of B1, B2s also next week.
Well, a person, Hannah, she's received an REF on her EB1A, and if you could talk more about how to go about an REF for an EB1A under the high salary category, and yeah, if you could take the question from here.
So I think you're saying that there was a request for evidence for an EB1A
Mhm.
for someone. So, I'm happy to talk about that a little bit, but our piece is really focused on the consular side, not the USCIS side, because we weren't USCIS officers. We didn't adjudicate USCIS petitions. We saw a lot of petitions and the evidence that was provided and the types of requests for evidence. So we can talk about it with some knowledge and familiarity. But our expertise is really on the consular side. I would just say that normally folks have an attorney they're working with or a petitioner that's got an HR department that they're working with. You'd want to be in very close consultation with those folks. If you're doing it on your own, great. That's impressive. There's a lot of folks out there who have experience on the internet that you could call upon the community to give you advice. Although I would be very, very, very thoughtful about the type of advice you get and accept from people on the internet. If you go look for me, Dean at visas101.com, all letters on Reddit, you'll see a bunch of answers I've been giving to people, but I also see a lot of bad information being given to people, a lot of bad advice. Oh, no, don't mention you have a girlfriend in the US. No, tell the truth, right? Like some really bad advice that's being provided out there. And then the other thing I would say is in terms of RFEs, take the time to provide a comprehensive answer that's directed at the requirement that they're asking about. So if they're asking about, these categories of, public events that you've spoken at or articles you've published or whatever, take the time to provide sufficient and fulsome responses to that, because that's really where the rubber meets the road. I interviewed a O1 one time in Kathmandu. This is in the early 2000s when I was a young consular officer. And the guy was a cook and it was an O1. And I was relatively new at consular work, but I was surprised. I expected to see, who did we see in Madrid? Shakira. I expected to see Shakira for an O1, not a cook. And I said to the gentleman, I said, O1 and you're a cook, you're a chef? And he said, yes. And I said, okay, well, what can you tell me about that? Can you explain anything? And he said, well, can I give you something? And I said, absolutely. And he slid a magazine under the window and he said, if you could just look at page 43, and it was New York Magazine. And there was an article about him on page 43 that ran for something like 7 pages about all the folks at the UN that he was cooking meals for. And it became very quickly apparent, because that was such a beautifully relevant and effective piece of information that established that USCIS knew what they were doing. I could see exactly why they made the decision they made. It made perfect sense. And he was qualified for the visa. It was very easy. If he hadn't have had that magazine, it might have been a harder conversation, right? So I would say you definitely want to focus your energy on really providing fulsome responses to whatever request they're asking for. Duden, did you have something you wanted to add?
Yeah, actually, I think that was really great, Dean. And, just to highlight too, O1s and EB1s, these are the kinds of visas that are reserved for people with extraordinary abilities. Truly extraordinary abilities. EB1 does not require an employer. You can self-petition for an EB1. So you have to say why you were just so incredibly special and unique. And I think it's important to keep that in mind because it is a very special visa category. It's a visa category that allows you to get an immigrant, visa and a green card in the US to live on your own without, an employer petitioning for you. So keeping all of that in mind and remembering that and looking at, the different kinds of evidence that you're submitting to the USCIS with your petition, I think is really, really, really critical. So if there's an RFE, request for evidence for a high salary, because the USCIS expects someone with extraordinary abilities to currently be employed with a high salary. Right? Because if you are someone with extraordinary abilities, that is what you would expect. So if there's an RFE for that, it's important to submit, as Dean said, as detailed a response as possible. The less RFEs you have, I think the better for your case, because it also speaks to the strength of your case and USCIS's assessment that you have a strong case in and of itself. So submit your case when you know for sure you have the strongest case possible for an EB1.
So I'd like to add, in the past, we've had a few AMAs with people who received the EB1A successfully. And I think a lot of them have touched upon the high salary point. And the two websites that come across to me are One Stop and the Bureau of Labor Statistics. Could you add to that? Because those were the two websites which I think on a lot of forums and Reddit, which I have seen and read about. So, are there any more that we can look at?
So, let me mention one more time what Dean had said. Neither one of us worked as USCIS officers. So this is actually something really important, I think, that we need to highlight, because
Okay.
I've had conversations with other people who were not on Unshackled, but elsewhere, who've said to me, so Duden, you were a USCIS officer. And I said, no. I was not a USCIS officer. I am a former visa officer who worked with the Department of State. When petitions were in front of us as visa officers, those petitions had already been vetted and approved by USCIS. So we never saw petitions that were shaky or that didn't get approved or that were at the RFE stage. Okay, we saw them when USCIS had already gone through that entire process and they approved the petition. And then we were tasked with interviewing the applicant, confirming all of the data. So imagine you already have an approved USCIS petition. You're in front of us and we're doing an interview. I'm here to confirm that you are who you say you are, that you are a rocket scientist who won a Nobel Prize. I'm here to make sure that you are all of those things. And sometimes people do misrepresent things on petitions. They claim to have worked somewhere for 5 years when in fact they worked there for 1 year. So those kinds of things do come up. And that is, I think, the really critical role of the visa officer is to have an in-person interview one-on-one and determine to the best of their ability if there is any misrepresentation happening or if there's any missing documents or if something is out of order. Because while a petition has been approved, if the officer has significant doubts with regards to the petition, there is always an option for them to send the petition back to USCIS for additional review. And this is something they actually don't have to necessarily share with the applicant. They may deny the visa under 221G and then proceed with sending a memo back to Washington about the reasons why they think there's issues with the petition to begin with. And so, these kinds of things do happen, and that is truly where we would come in as former visa officers in terms of providing guidance. But we can't tell you what specific websites to look at for salaries, for example, because that is not something that we were involved with as visa officers or in consular managers.
So I think we have, thank you for taking that, Duden. We have a question again for an REF. Does an REF from an immigration petition like EB1A impact the chances of approval in an interview process for something like an H1B extension?
Yeah, it's a good question. It's unlikely to have an impact. They're really two separate processes, right? Like you might qualify for an H1B, but not yet have the, expertise, the salary, the notoriety, the impact to qualify for an EB1A, right? So, or maybe you do, there's that back and forth going on with USCIS, but that's not really relevant to whether or not you are whatever you are that qualifies you for an H1B. So, it could come up, but you don't need to overcome the presumption of immigrant intent for an H1B. So the fact that you've got this other process going on, this immigrant process, it's a concept known as dual intent, where you're not an immigrant right now, you're a non-immigrant right now applying for an H1B. We recognize that you're going through this immigration process, but there's no reason to assume that if that's not approved, that you're going to somehow abscond in the United States, you're an H1B. So for most consular officers in the space of O's and H1Bs and L's, as long as you're qualified for that non-immigrant visa, the fact that other process is ongoing shouldn't be a problem. In fact, even with some immigrant cases, if somebody's applying for a B1, B2, and let's say I don't know, they're applying to go for vacation for a B1, B2 as a 16-year-old to Disney World, and they are the child, their parent's sibling is an American citizen and is petitioned for them. The fact that petition is ongoing doesn't mean that they're an immigrant in this moment. It might, consular officer might ask about it, but it is possible to do both of those things, to go on a vacation, and then when you come back from that vacation in the United States, you're going to apply for your immigrant visa. And as long as the officer thinks you're going to use that non-immigrant visa properly, or in this case, you qualified for the H1B, then it's very unlikely to have an impact. Duden, anything to add?
No, I think that was great. Yeah, absolutely.
So we have a question around B2 visitor visas. Sorry, I have to find the question. Is the primary intent for this visa just tourism or visiting family as well? And if you have any advice for parents who are visiting on a B2 visa frequently?
Yes.
Yeah.
Can I jump on this one?
Sure.
So yeah, look, most non-immigrant visas are individual, right? So if you're applying for an H1B, you don't get an H1B. Let's say you want to apply for a student visa and a tourist visa at the same time. You can do that. You can apply for an F1 and a B1, B2. You're going to pay 2 visa fees. You're going to put them both on your visa application. There's going to be 2 visa foils, or people call them stickers, but they're visa foils in your passport, one for the F1, one for the B1, B2. The B visa is a special category where if somebody is issued in most countries, there's some rare exceptions. If you're issued a B1, you're issued a B2. If you're issued a B2, you're issued a B1. So normally you get a B1, B2 at the same time. B1 is for business. It doesn't mean you can come here and do business work here, but you can come and have meetings and negotiate contracts and take orders and do that kind of stuff. And B2 is for tourism. So tourism, visiting family, going to the Grand Canyon, going to Disney World, any kind of touristic activity. And there's a long list of business type activities that are permitted on a B1 and a long list of tourism type activities permitted on a B2. So yes, if somebody wants to come visit family, if you have family members, if you're on an O or an H1B or an L, you have family that wants to come visit you, they would apply for a B1, B2 visa. And the advice, there's 2 pieces of advice I would give. The first one is they should take our course. And the reason I say that is because understanding what the consular officer is doing in the interview for a B1, B2 visa is something that most people don't understand. And what I mean is the consular officer for a B1, B2 visa is assessing whether the person's planned activity in the United States is consistent with the visa category. In other words, I want to go visit family and I'm applying for a B1, B2 visa. Good, that's fine, that's allowed. If you say, I'm applying for a B1, B2 visa and I'm going to go take a college class, they are going to deny you the visa, even if you would otherwise qualify for an F, because you can't do that activity on a B1, B2. The other thing the consular officer is doing is assessing whether or not you intend to follow the rules of the visa, have a short visit, and come back. In other words, that you overcome a presumption that's written in US law that you are an intending immigrant. It's called the presumption of immigrant intent. What that means is when an applicant walks up to the window, they start out according to US law. This is the officer has to follow this. That person's not qualified for the visa. They have to overcome that presumption that they're an intending immigrant and therefore not qualified for a non-immigrant visa. And so understanding the kinds of questions that the officer might ask and knowing how to answer those questions in a way that demonstrates that you are not an intending immigrant, assuming you are not, is key. And I can give you an example. Why do you want to go to the United States? And the person might say, to visit family, to visit my daughter who's on an H1B in California. Well, my daughter who's on an H1B in California really wants me to visit. I only have a week because I have to get back to my job at blah, 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 blah. And my other son is in college here and he needs my help. So I can only go for a week, but I'm going to visit my daughter who really wants me to come see where she lives. The first one is a fine answer. It's a true answer. The last one answers the question, not only why you're going, but that you'll come back. And so understanding that and approaching that interview in a way that that leverages every opportunity to make that case to the officer in a 2 to 3 minute interview is really important. And that's a big piece of what we cover in the class and why I wanted to sort of highlight that. Duden, sorry, I talk a lot. Go over to you.
That's okay. No, I mean, yeah, all true. And to answer the question very simply, yes, you can go visit family on a B2. Absolutely. That's a totally valid reason for a B2, B1, B2, as Dean highlighted. But one thing I will say is one of the bonus documents that we offer as part of our B1, B2 course is a list of permitted and not permitted activities. So I think that's a very useful document, bonus document that we offer in the B1, B2 class, because it does go deep into what are the kinds of things that are allowed on a B1, B2, and what are the kinds of things that are not allowed on a B1, B2. So I'd highly encourage, everybody to take the course and take advantage of these bonus documents. The information is out on the internet, but having them all together in a very nice compact fashion is something that is very hard to come by. And so as experts in this field, we have prepared these documents specifically to be able to assist visa applicants. And we encourage everybody to take advantage of that. So.
We have another question from Siva from an EB1A standpoint. So Siva, would you like to unmute yourself and ask your question?
Sure. So I'm on a H1B visa right now for my employer, and my profession is like a senior software engineer. So I have incorporated my company with my co-founder. So our company basically built an app for restaurants, like connecting users. You can think of like similar, so I say something similar to DoorDash. So my question is like, I plan to go for O1A or EB1A, and one of the criteria for these two visas is like press media coverage. So we hired a development agency to build the app. So technically, like I'm not writing any code for the app or something. But when I go for a press release or something, should it say like Siva is the founder of the company? Is that enough, or it should? The press coverage should state like Siva built the app, like wrote code or something like that. I know this is kind of like a nuanced thing, but at least like some high level thing would just like help. Yeah.
So Siva, thank you for the question. Again, because we're not USCIS officers, it's hard for us to like, if you were talking about a consular interview and you said, well, should I say this or should I say this? I can tell you why one might be better than the other. Whereas for the petition piece of it, I don't think we have the expertise. I don't want to suggest that we've got expertise that we don't have and steer you in the wrong direction. I would say that whether or not you coded, if it was your idea and you are managing the creation of it, then saying something like you created, think about the different kinds of verbs you can use to encompass the thing that you did. But for that kind of thing, I think you really want to talk to somebody who's got that kind of expertise in applying for that, whether that's an immigration attorney Or Duden, I don't know if you have other suggestions, but that's really just, I don't want to steer you in the wrong direction, give you the impression that we have expertise that we don't have. That's our specialty is the overseas piece, the visa interview piece.
Got it. Cool.
Absolutely.
Thank you very much.
Absolutely.
I do not see any more questions on our chat.
The one thing I will mention, Priya, I don't know how many of your members are currently in the US on a student visa, for example. Do you have an idea?
Well, I am on a student visa.
You are on a student visa. That's great. Congratulations.
Thank you.
The one thing I will mention is this. Oftentimes people think, I'm going into this interview, I have an approved petition, everything is going to be fine because the USCIS has already reviewed everything and my petition is approved, and I'm just going to go for my visa stamping. Exactly what we mentioned at the beginning of our session. What they don't realize is, for example, for an O1, how you have acted on prior visas in the US, the things you were engaged in, what you did may come up during a completely unrelated visa interview. So I will mention that, when you are in the US, you really have to make sure that you're following the rules of the visa that you're currently on, whatever visa that might be, even if you're here on a B1 B2 or a student visa, or some other H1B, whatever kind of visa you might be here on, you need to make sure you are following the rules of the visa, that you are not engaging, for example, in unauthorized employment, that you are not overstaying your visa, that if you've changed employers, you're, alerting the authorities about the change in your employer, et cetera, et cetera, et cetera. I mean, the list is endless. And so I would just highly encourage you to be very mindful of the kinds of activities that you're engaging in while you're in the US, and making sure that everything you're doing is okay under your current visa status. Because things do come up. We've seen it with our clients. We have seen it at the visa window when we were doing visa interviews. Visas have been denied because of issues that have come up in situations like the ones I've just stated. So I would just encourage you, whatever kind of visa you are currently on, make sure you're following the rules. And even if you have a strong petition, it is not a guarantee that your visa will be approved. So be mindful of the two different processes. And if there's anything you take away from this session, it is that USCIS and State Department are two different entities. They are not under the same umbrella. They work hand in hand, but they don't report to the same authorities, if you will. They don't report to the same department. They even report to different departments. And so give the due respect to the USCIS process when you're filling out your petition and applying. Do the same when you're applying for your visa. Understand that the two are separate but much needed parts of the same process.
Thank you. Thank you for that. I did have a question myself. In all the different categories of the visa, is there an average interview time that one should prepare for? Or how would one should go about preparing for it?
Are you talking about like how long does an interview last?
Yes, because I've seen that the student visa or a research visa, they relatively last for maybe 10 to 15 minutes. But however, I'm curious to know how long will the other visa interviews be for?
So Dean, if it's okay, I'm happy to take this one.
Sure.
And then you can fill in if I'm missing anything. So when there is no paper involved, so let's say a B1 B2 visa, typically there's no paper involved with a B1 B2 visa. That interview should go from, anywhere from 1 to 3, 4 minutes. That's typically the length of a B1, B2 visa interview, although sometimes it might take longer depending on why the applicant wants to go to the US, because there's so much you can do on a B1, B2, and it may get complicated very fast. When it comes to a student visa, there is additional documents that are involved, right? You're checking, you know, the I-20, or you're checking the DS 2019. There's other documents that you're looking at for a student or exchange visitor visa. When it comes to a petition-based visa, like an O1 or an EB1, with an EB1, it's even, I would say, more because it's an immigrant visa category. There is more checks that need to be done. There's more of a conversation that needs to be had. So the visa interview time may be slightly longer. If it's a non-immigrant visa, a little shorter. If it's an immigrant visa, a little longer. And in fact, many embassies schedule non-immigrant and immigrant visas at different times. So you may not have an officer looking at immigrant and non-immigrant visas in the same, you know, time period. They may just be doing non-immigrant visas in the morning and immigrant visas in the afternoon. So even that may be slightly different, because with an immigrant visa, you do have to check so many additional things. So that visa interview typically takes a little longer. Dean, am I missing anything?
No, I think that's a great answer. The only thing I would add is that there are cases where it's very, very fast. If you have a B1, B2, and you're getting a new B1, B2, because your old one's going to expire, or it just expired, and let's say for whatever reason you didn't do the Dropbox, you could, but you didn't, and you're there. That's just that, unless something comes up, that's not going to take very long, right? The decision I have to make as the officer is this person going to follow the rules of the visa, and for the last 10 years they've been following the rules of that visa. I've got no reason to think they're not going to. I don't need to have a whole conversation with them about it. They've already demonstrated that, right? So if you're renewing an F1 and your SEVIS record is good, you've not been out of status, you know, those things are going to go very, very fast. So sometimes it can go even quicker. You have to remember that the consular officer's got maybe 80, 90 people standing behind you, depending on what time of the morning you apply, that they've got to interview too, right? So they want to go as quickly as they can, so that nobody has to wait very long, and so that everybody gets a fast and thoughtful and considerate opinion. For certain visa categories, you start out not qualified, so you have to qualify quickly, because there's not going to be a lot of time. But I thought Duden's answer was great.
Thank you. I have one more follow-up question. On the self-petitioned visa, the O1s or the EBs, is it advised to go for, or can we go for the interview at a consulate versus within the United States? Or if somebody's traveling, what would you suggest in that scenario if they want to, change their interview location? Is that possible?
If you're in the US already on a non-immigrant visa and you're going to change to a different non-immigrant visa category, you can apply for a change of status with USCIS. You can do that on their website. So if you're here on an F1 and you're filed a petition and that petition's been approved, there's a change. It's possible to change status. But then as soon as you leave the United States, you no longer have a visa. Remember that the US does it a little bit differently than most countries. Most countries, the visa is permission to come in and be in that status doing that thing. For the United States, the visa is permission to come to the port of entry and to seek admission. And it's CBP at the port of entry that admits you and admits you in a particular class. Now, normally, if you have a B1, B2 visa and you show up at the port of entry and you say, I'm here to go to Disney World, they're not going to admit you as a student, right? On an F1 status. They're going to give you a B2 status for 6 months admission, blah, blah, blah. But nevertheless, that visa is permission to travel to the port of entry. So let's say you're in the US. Let's say you come on an F1 visa and you do your undergraduate. And then while you're here, you apply to graduate school, you get admitted, you submit for a change of status from F1 to F1, but with your new case, your new SEVIS number at the new university, you do your graduate degree and then you do your PhD. You might be here that entire time. Let's say 12 years, you do a PhD, undergrad through PhD, you do a PhD in, I don't know, chemical engineering. You've been here for 12 years and your visa expired, I don't know, 7, 8, 9 years ago. You don't have a physical visa anymore. You no longer have a visa, but you are legally here in status and you're maintaining your status, which is perfectly fine. Now, let's say, 3 years before you're done with your PhD, somebody's getting married back home. You got to go home for the wedding. You need a new visa to come back, right? With that new I-20, with that new SEVIS number for your PhD program, because you can't get on a plane without the visa. But while you're here and you're maintaining status and you're in status, you don't need another visa. Iranian students get single entry 3-month visas. So the minute they're admitted to the United States as a student, their visa, they no longer have a visa, right? So if they ever leave, they have to get a new visa. But while they're here, as long as they're maintaining status, they're in status.
Does that make sense, Priya? Because I think what you need to remember is this. Visas are only issued overseas.
Okay.
The US government does not issue visas in the US. Because visas, once again, are something that the Department of State issues, not Department of Homeland Security. So USCIS, which is the petition entity, or the entity that also approves, for example, changes in status, that entity is a US-based entity, and they are under the Department of Homeland Security. Visas fall under the Department of State, and the Department of State does not issue any visas in the United States. They only issue visas overseas. At a US
Well,
entity
let me
or
just
consulate.
let me just correct that, because there's a couple very, very fine points that everything Duden said is generally correct. There are diplomatic visas for people at the UN that are issued in the United States. That's something that doesn't apply to anybody here.
No.
And just in December of this last year, the Department of State started a pilot program to renew some H1B, some petition-based visas in the United States. And assuming that goes well, I think they'll expand that. And so they may, in fact, start
Doing
issuing
or,
renewals of like H1Bs and Os and Ps and Ls at some point in the United States. But generally speaking, the visas, even if they
But extending
apply
visas,
for a renewal in the United States, it's issued in the United States. It doesn't actually matter for your status in the United States. It's only relevant when you leave because it's what you need to travel back. But while you're here, you don't need that physical, you don't need an H1B visa if you're in H1B status. So once you've been admitted, if your passport goes through the shredder, you're still in status, you're fine. You just would need a new visa if you're going to travel.
and you'd need a new passport.
Yeah, right.
So you would need to contact whatever embassy or consulate that you belong to in the US. If you're an Indian citizen, you need to contact the Indian embassy to make sure you have a passport to go back home with. But I mean, long story short, Priya, if you, for example, I mean, Dean, how would it work for an immigrant visa? So if you're in the US and you're on an O1 and you applied for an EB1, let's say, are you able to get a green card without leaving the US? Or do you have to have an immigrant visa?
So you can file both an I-140 petition for the EB1 and an I-485 petition to adjust status.
So if you don't leave the US during that entire process, it is possible for you to get a green card without stepping outside of the United States.
Right. And if during that period you filed the I-140 and the I-485, and then for some reason you have to go back home, the I-485 may be abandoned and you might need to apply for the immigrant visa overseas in order to come back, unless your O1 is still valid. You come back on the O1 and that process continues. So it gets very case specific on how it works and what you need to do. But folks can file. If you marry an American citizen, that citizen can file an I-130 for you. If you're overseas, you apply for an IR1 or a CR1 visa. If you're in the US, they would file the I-130 and I-485, both to petition for you as the spouse of an American citizen, but also requesting the process to adjust status in the United States. So anyway, it gets very complicated, very case specific.
So it's honestly a question of whether you leave the US while you're in between a change of status. So with a green card, you can travel. You don't need, if you have a green card, you don't need a visa in your passport. The green card is your travel document in addition to your passport. But if you don't have a physical green card, you either need to be paroled in if you're in an in-between status, or you actually need a physical visa in your passport. So if you need a visa, then typically, especially if it's not a renewal under a pilot program, as Dean mentioned, you have to apply for a visa overseas in a US embassy or US consulate.
And considering wait times as they are at most embassies and consulates around the world, it pays to anticipate, hey, next summer I'm going to be going home for whatever reason, and then I'm going to need a new visa to come back. And so I'm going to get on that embassy appointment website and I'm going to keep an eye on it. And as soon as appointments open up for next August, I'm going to make an appointment. Because if I wait until next May, I may be out of luck, right? Because the wait times are just terrible at a lot of posts around the world.
And before you travel, I would always encourage you to consult an immigration professional just to make sure everything is fine, especially if you're kind of in an in-between status situation, you know, because you don't want to leave and not have a way of getting back in. So that always creates issues.
Thank you. Thank you for answering that.
Sure.
Well, I do not see any more questions. So does anybody have any more questions?
Hey, hi. I have one question. This is Jay. So I remember, so this is pertaining to again EB1A. I remember like one of the demonstrations of like your accomplishments is like the authorship. So I'm a software engineer, and so do I need to publish papers or demonstrate any research papers, or if I write an article for something like medium.com or something like that, that's good enough for demonstrating that as like significant some authorship in my domain.
So Jay, let me revert back the question to you.
Okay.
What area you said you're in? You're in computer science?
Yeah.
Okay. So for someone who is in computer science, if you were to read an article on Medium, would you say that person has extraordinary ability? So you have to think about it from your domain's perspective, right? So if I'm a chemist, where do I need to be publishing articles? Well, I should know, if I'm a chemist, what journals are the highest level publishing institutions in my domain. If I am a journalist, is publishing on Medium enough, or should I have some articles in the New York Times? These are the kinds of questions. I think one of our bonuses is the self-reflection questions. Now, again, we don't deal with USCIS petitions because that is not our area of expertise, but we have seen approved petitions. So with approved petitions, those are petitions that USCIS has already determined meet the requirements and the qualifications. So I would, if you're doing this on your own, and I would highly encourage you to work with an immigration attorney, but if you're doing this on your own, I would kind of ask you to ask yourself some of these questions. Knowing your domain, and if it's computer science, it's computer science. I'm not a computer scientist, so I wouldn't know. But if computer science is your domain, you as a computer scientist, where would you read an article that would get you super impressed about someone in your field? Would it be medium or would it be elsewhere? So ask yourself these questions. Would you be convinced that this person has extraordinary abilities in computer science if you read an article on Medium? Or would you need something else? And if you would need something else, what would that something else be? What would impress you as a computer scientist for you to think this person has extraordinary abilities?
Got it. So yeah, thanks for answering. So yeah, so basically, yeah, I was just kind of had a question on like, does the publication needs to be a research paper, or it can also be an article in a very good place, like some. So feels like, I think with your answer, it can also be at a very good, in an article at a very good place, which is like a technical place that can also show extraordinary abilities. Am I correct on that?
So I would recommend you to gather a whole host of evidence. Typically it's not one article. Typically it's not one thing. It's several articles, several awards, it's this, it's that. It's a comprehensive petition that you're preparing. It's multiple letters from people in your domain. There's so much that goes in a petition. That's why the petitions are like this big typically, right? So I would highly encourage you to, again, talk to an immigration attorney if you can, who has experience submitting not just any EB1, but submitting EB1s for people in your field specifically, because I think each field is slightly different. I mentioned, because you can get an EB1 as a journalist, right? So if you're a journalist with extraordinary abilities, you could potentially get an EB1. So I mentioned the New York Times for that reason. But for computer science, it might be different. For a chemist, it might be different. For a chef, it might be different. Because there are people who can get EB1s under a whole host of different domains. So I would encourage you to gather as much evidence as you can and not just rely on one article, on one thing. I think you got to take this step by step, but to make sure that you have a whole host of evidence when you prepare your petition, and talk to someone who knows petitions for computer scientists. I don't know, Dean, if you have anything.
I would just say, Jay, you may have looked at this already, but I put a link in the chat from the USCIS website where it lays out how to demonstrate extraordinary ability. So it talks about published material in a professional or major trade publication or other major media. And I think Duden's answer is really solid. Like, you as a computer scientist know better than I think we do on what kind of computer science articles or publications that publishing in is meaningful. My brother's a material scientist, and I know he's published in a lot of different scientific journals, but I also know that when he published in Nature, it was a really big deal, right? And I wouldn't have known that. Like, he told me, like, this is a really big deal, because Nature is the big one for material scientists, or I guess probably generally in the science field. It's one of the biggest, the most impressive, whatever. I'm not a scientist. I don't know that, right? So use your own knowledge of the field that you're in to, if you were assessing somebody else's qualifications for an EB1 against the requirements that are laid out on that webpage that I provided the link, and then you're looking at what you've got, you'll have a pretty good sense of whether it's sufficient or there needs to be more. What's most appropriate? What are the things that are appropriate for the field? So I think Duden's answer is really, really pretty solid. But that website does lay it out pretty clearly. You need X number of, from category 1, or for this one, you need 5 from category 2, or whatever. It's on that website. So that's worth checking out.
Great. Yep. Thanks, Dean. Thanks.
And good luck.
Yep. Thank you.
Well, we've spilled our time by 6 minutes. Apologize for that. I do not see any other questions from any of the participants on our chat. So I'd like to say thank you for all the advice that you've given us. And if you'd like to add anything before we close the session.
No, I'll just say, you know, we're here to help and support you. I hope this helped clarify, you know, some of the differences between USCIS and the State Department processes and the differences between a petition and a visa. But we are here to help and support you throughout your journey, especially when you come to the end of it, when you're applying for your visa. But we wish you the best of luck and hope this was helpful and useful.
It was. Thank you so much.
Thank you.